Hello, today we're going to revise contract law. I'm Nini, founder of StudyCrowd AI, formerly known as Simple Studying. I have LLB and LLM degrees from City University of London. I've got high 2-1 and first class grades in my assessments at law school, and I founded StudyCrowd AI to help students get high grades. We help UK and US university students to get high grades with AI and human tutoring, as well as career mentoring services and personalized simple study materials. Why you should trust us? We have over 25,000 registered customers already on our platform in the UK. That's like 25% of total number of law students in the UK. 90% of our regular customers have reported to have got a first class after getting our premium subscription and using our premium subscriptions to study with regularly, as well as at least 6 hours of tutoring. It is recommended for you to get as many tutoring hours as possible. Tutoring is only going to help you because it's a personalized support that our tutors give students to maximize their chances of getting first class in coursework and exams. However, 6 hours is the recommended package to start with. After working with thousands of law students, we know exactly how to get a first class law degree. And if you get our premium subscription and tutoring services, you will get the necessary support you need to maximize your chances of getting a first class law degree. What you should revise for your contract law exam in particular? We suggest you do selective studying if you have an exam. So in an exam, let's say you need to choose at least 3 questions out of a set of 6 or 8, then you can do some selective studying. You don't need to revise every single topic that was covered on your course, but you can select the ones that you understand the most and you feel the most confident with. I suggest you revise at least these 4 topics: formation of contract, misrepresentation, exclusion clauses, sale of goods. The reason why I suggest you to revise these topics is because it usually comes up, like from all the contract law exams that I've seen in my life, these topics are very common to come up as a problem question or an essay question. So accordingly, I suggest that you revise these 4 topics. What is formation of contracts? For a contract to be created in English law, you need an offer, acceptance, consideration, and intention to create legal relations. You need to know what these 4 components are and the main case law around it, so you can apply it to the facts of the case and provide critical analysis. If you have these 4 ingredients, then potentially you have a valid contract. What is misrepresentation? Misrepresentation is false statement of fact or law which is addressed to the party misled and induced the contract. After establishing that there is misrepresentation as per the definition above, and by application of the relevant case law, talk about what kind of misrepresentation it is. Is it a fraudulent misrepresentation, negligent, statutory, or innocent? So first you have to establish that it was a false statement of fact or law by application of the relevant case law, and then you need to discuss what kind of misrepresentation was it. Sale of goods and implied terms. It's very important for you to memorize section 13, 14 and 15. Section 13 states that goods shall correspond with the description. So if you buy something and then you find out that it was not what you bought because the description was different from what you got, that's a breach of an implied term under Sales of Goods Act, and that's section 13. Section 14, on the other hand, states that all the goods must be of satisfactory quality and fit for purpose. So, for example, if you buy a phone, the purpose of a phone is to at least call, right? So if it cannot call, then it doesn't fit for purpose. It has to be of satisfactory quality and it has to fit for purpose. It has to be able to fulfill what it's supposed to do. And section 15, sale by sample. And sometimes businesses buy goods by sample, so they see a sample and they order large quantity of goods according to that sample, and if the sample doesn't correspond with the product that the buyer got, then it can be breach of Section 15. Here's the example question that you may get, something like this, on your exam or coursework. Company 1 sells construction equipment. In January 2025, John, director of Company 2, who is not a construction expert, wants to buy construction equipment for his family business that he just took over. John went to Company 1 to buy a construction truck. They had a truck manufactured in France, which was a left-hand drive. He was told that left-hand drive trucks are legal to drive in the UK, which was incorrect. Does John have an actionable claim for misrepresentation? So he bought a truck which was left-hand. He was told that it's legal to drive a truck like this in the UK, which was not legal. So can he sue for misrepresentation? That's what you need to discuss. Let's see. In a problem question like this about misrepresentation, the structure should be the following. First, you need to identify the false statement of fact or law. So it can be either a factual statement or a legal statement. And then you need to critically analyze if it is false, addressed to the party misled, material, and induces the contract. So it should not be some kind of comment that did not really have any significant importance. It has to be very, very important and crucial, which induced the contract, which was the primary motivator for the buyer to enter into the contract. Second, discuss which type of misrepresentation it is. Fraudulent, negligent, innocent, not a straightforward answer. Most likely you will have to discuss each one of them. And third, apply all relevant case law in your arguments. In law, you're not supposed to give yes or no answer. That's not your job here. Your job is to discuss all potential answers by application of relevant case law. The examiner should be able to see that you understand the law and you are able to make critical analysis. The final answer is of less importance because the most important part is for you to identify the right law, discuss the relevant cases, then apply the case law to the facts of the case and make arguments. And finally, you can have conclusions. And finally, you need to discuss remedies in contract law. What kind of remedy are there for misrepresentation? Legal issue 1, misrepresentation of law. Here, John was told that left-hand drive trucks are legal in the UK, which was false. So it was a false statement of law. Or was it a mere puff? That's what you need to discuss according to the judgment of Carlyle versus Carbolic Smoke Bar. Was it addressed to the party misled? There was direct communication to the claimant. So most likely, yes, that it was addressed to the party misled. They were not communicated through a third party. They were talking directly to each other. Inducement. Look at the case of Edginton versus Fitzmaurice. The misrepresentation need not be the sole inducement, but nor must it have been decisive. So the inducement does not need to be just one thing. It can be multiple factors why the contract, the sole inducement of the contract does not need to be the misrepresentation. There can be other factors there. Fraudulent. For fraudulent misrepresentation, you need to apply the test which was set out in Derry versus Peake. And the test for fraudulent misrepresentation is first, you need to prove fraud. Second, you need to show that there was false representation, which was made knowingly or without belief in its truth, or recklessly, careless whether it would be true or false. If fraud is proved, the motive of the person guilty of it is immaterial. And finally, you need to discuss remedies such as damages and right to terminate the contract. Negligent misrepresentation. This is a different kind of misrepresentation, which is relatively easier to prove than fraudulent misrepresentation, because for fraudulent misrepresentation, you need to prove fraud, according to the case of Dairy versus Pig, which is quite hard to prove. So in practice, you can advise your client in the problem question that negligent misrepresentation would be easier to prove, because you don't have to prove fraud in case of negligent misrepresentation. So negligent misrepresentation is a statutory type of misrepresentation which is set out in section 1 and 2 of the Misrepresentation Act 1967. These are the questions that you need to discuss. Did the claimant suffer loss? Was the defendant fraudulent? If not fraudulent, can the defendant prove that he had actionable ground to believe that what he was saying was true? So did the defendant make a false statement knowingly, or he thought that he was saying the truth? Finally, make sure that you discuss the remedies: breach of contract, damages, specific performance, and injunction. Those are all possible remedies that can take place in case of breach of contract, and depends on the circumstances which one is more relevant. So in this case, what is more relevant for John? Does he want compensation, monetary compensation? Does he want injunction, specific performance? Most likely it would be termination of contract and compensation based on the facts of this case. To learn more about contract law, the topics that we discussed today, or other topics, please check out studycrowd.ai. If you go to studycrowd.ai and search contract law, you will see all the revision notes, case summaries, model essays, quizzes, tutorial videos, and flashcards. All these study materials are specifically designed for UK law students to maximize your chances of getting a first class in contract law. And also, don't forget to sign up for tutoring. Even though we have on-point, simple, condensed study materials that is just giving you the right information you need to maximize your chances of getting a first class, tutoring is a personalized support that goes on top of it, on top of the study materials, to help you even further to understand how to answer problem questions and essay questions correctly to get high grades. Thank you very much, and hope to see you on other revision classes.